بسم الله الرحمن الرحيم. Good evening dear students. كل سنة وانتم طيبين. طبعا بمناسبة شهر رمضان، أول محاضراتنا في شهر رمضان المبارك. كل سنة وانتم طيبين. خلص تمنياتي لكم بالتوفيق إن شاء الله والنجاح. Today we shall complete our discussion regarding to environmental law. In previous lectures we talked about in detail and explained required criminal intent, and we said that there are 4 categories of intent. Criminal intent. Criminal intent, we said in last lecture, divided into 4 states of mind, listed in order of culpability, or according to culpability, or according to degree of awareness. And we said that criminal intent divided into 4 states, 4 categories: purposely, knowingly, recklessly, and negligently. Purposely means intentional or purposely. In such category, defendant not only knew what he or she was doing, but intended it to happen. So, defendant in such a category of intent engage in conduct with a purpose to cause certain bad result. Defendant who acts purposely intends to engage in conduct of that nature and intends to cause a certain bad result. Purpose for criminal intent. Purpose for criminal intent resembles specific intent to cause harm, which discussed previously. So, a defendant who acts purposely with respect to a material element of an offense when the element involves the nature of his conduct or a result thereof. It is his or her conscious object to engage in conduct of that nature and to cause such result or such bad result. Purposely or intentionally can be narrow, but involves conscious object to cause result acts with knowledge that conduct virtually certain to cause result. For example, if A planes pump in plane to kill B, for example, other die, also D intentionally killed A and B, virtually certain that B will die as a result. So, anything can be inferred from circumstances. So, purposely means conscious object to engage in conduct is aware of existence of a tense circumstance or believes or hopes that they exist. While knowingly the second category of intent, knowingly means that the defendant engage in conduct without purpose to cause certain bad result. Knowingly means that defendant or indicates that the defendant is aware of nature of the act, his or her act, and its probable consequences. So the difference between knowingly and intentionally is around. And intentionally or purposely defendant engaged in conduct with a purpose to cause certain bad result. But unknowingly, he had to be aware only of the nature of the conduct and its probable consequences. So, certainty in such regard not considered. Knowingly differs from purposely in that defendant is not acting to cause certain bad result, but is acting with awareness that the bad result is practically certain shall occur. So knowingly can define as a person acts knowingly with respect to material element of an offense when he or she were aware that such conduct is of that nature if the element involves a result of his or her conduct and he were aware that it is practically certain that such conduct will cause such bad result. Some common laws, crimes require knowledge of attendant circumstance also. What we mean in such regard with knowledge of attendant circumstance, we mean that aware of fact, correctly believe that such a fact exists, suspects that it exists, and avoid learning. So, knowingly with attendant circumstance or conduct, one acts knowingly if he or she were aware that his or her conduct is of that nature, or that such attendant circumstance shall exist as a result of such conduct or prohibited conduct. One acts knowingly if he or she were aware that it is practically certain that his conduct will cause such bad result, but he were not engaged in conduct to cause certain or such bad result. So knowingly require that prosecution to prove that the defendant knew what they were doing, okay, and the existence of required circumstance, and that the result shall occur. Knowledge as an element of intention must cover all requirements of the crime. We have already pointed out in previous lectures that intention consists of two elements, namely knowingly and well. Knowing and well. Knowledge and well. It is necessary to explain the knowledge requirement of and the cases in which there is a mistake either of fact or law. اتكلمنا في المحاضرات اللي فاتت يا ولاد عن الركن المعنوي بصفة عامة، واللي هنتطرق منه لصورة أو صور الركن المعنوي في جرائم البيئة. قلنا بصفة عامة إن الركن المعنوي هو الجلت مايند، الإرادة الآثمة. والإرادة الآثمة لها 4 صور. ال4 صور ما ينفعش يبقوا موجودين مع بعض، صورة منهم فقط اللي تبقى موجودة. البيربس دي اللي هي intentionally, knowingly, reckless and negligently. قلنا البيربس دي الديفندنت أو الجاني بيرتكب السلوك بغرض تحقيق نتيجة. بغرض تحقيق نتيجة. أما في النونلي لا، بيرتكب السلوك وهو عارف إن النتيجة براكتيكالي بتحصل، لكن هو ما قصدش إحداث النتيجة. أوكي؟ ويمكن إحنا قلنا كمان إن بيبقى في بعض التشريعات awareness of attend circumstance، وفرقنا بين attend circumstance والaggravating and mitigating circumstance. قلنا ال awareness of attend circumstance هنا consists of aware of fact، الحقائق أو الوقائع، إن يكون correctly believes that it exists as a result of his conduct, suspect that it exists and avoid learning it. يعني هو مدرك ان الاتنس سيركمستانسز دي هتقع، ولكن عمل avoiding للlearning of it. اوكي، لكن هو ما قصدش احداث النتيجه. وقلنا ان بتقابلنا هنا مشكله فيما يتعلق بالميستيكس. هل الميستيكس هنا هتاثر، سواء الميستيك اوف لو او الميستيك اوف فاكت، هتاثر في التشارج، هتاثر في اللايبيليتي ولا لا؟ اوكي، هنتكلم الاول على الميستيكس والميستيكس اوف فاكت. In order to have intention dependent knowledge must refer to all the elements of the prohibited offense or prohibited conduct except the requirement of culpability. Such knowledge must refer to act, as we said 4 minutes ago, circumstance or attend circumstance includes and definitional element and unlawfulness of such conduct. The defendant must be aware of all these factors. Let us now apply such rules to specific crimes, namely common law perjury. The form of culpability required for such crime, intention. The elements of such crime are the following: making a declaration which is false. Declaration must be false in the course of legal proceeding. Fourthly, unlawful and intentional. If we now apply such rule presently under discussion to such crime, it means the following: 1. The act and definitional elements are contained in elements. Number one, making a declaration, and 3, in the course of legal proceedings. An application of the present rule means that, firstly, that the defendant must know or be aware of facts, and he is making a declaration, or that he is making a declaration. He also must know that such declaration is false. So you had to be aware of a falsing of such declaration which he write or made. Furthermore, defendant must know that he is making a declaration under oath. If he were not aware of such points, a material component of intention requirement for that such crime is lacking in such regard. And the accused could not be convicted of such crime. So there is no charge if he were not aware of such elements. Intention in respect of elements. Number three, in the course of legal proceeding of the crime means that such a defendant must know that he is making a statement in the course of legal proceeding. If he were aware of such point, where, for example, he thinks that he is making a statement merely in the course of an administrative process, a material component of the intention required for such crime is likewise taking. Intention in respect of elements unlawfully, okay, which we discussed from minutes ago, of the crime means that defendant must know that his conduct is unlawful. So, in such a case, this is not covered by ground of justification. It is not necessary to require into intention relating to intentionally as element of the crime. And this element is the culpability element itself. And an intention in respect of an intention is obviously nonsensical. One may illustrate the rule that intention must relate to all elements of the crime graphically as follows. One, intention had to be direct to all related to all elements of the crime. Intention had to be directed to all circumstances include and definitional elements by saying that the intention must be directed to circumstances included in the definitional elements. We mean that defendant must have knowledge of such circumstances, attendant circumstances. Such principle applies practically to formally defined crimes, okay, rather than materially defined crimes. Because in formally defined crimes, the question is not whether defendant act goes certain but merely whether the act took place in certain circumstances. The following are examples of the application of such principle. For example, in the crime of unlawful possession of drugs, the object in such regard, or the object that the defendant possess must be in such regard a drug, and defendant must accordingly be aware that the fact that what he possesses is already drug. We had to be aware that what he possesses is drug. If the defendant is under the impression that what he possesses, or if he will possess a bottle that someone had asked him to keep contains talcum powder. Well, in fact, will contain drug. Defendant lacks intention in such regard. It follows that the definitions of different forms of intention is formally defined crimes differ only slightly from the definitions of the forms of intention in materially defined crimes. The only difference is that all references to causing result, bad result, are replaced by word, commit, and act, and where applicable circumstances exist. Intention with regard to unlawfulness, as far as the intention with regard to unlawfulness is concerned, the principle which has been explained above as applies. Knowledge of unlawfulness of conduct is knowledge of fact and is present not only when defendant in fact know that his conduct is unlawful, but also when he merely foresees the possibility that it may be unlawful and reconciles himself to that. His intention with regard to unlawfulness is then present in form of dolus eventualis or when we say that knowledge of unlawfulness is required for the defendant to have intention, it means that the defendant must be aware that his conduct is not covered by ground of justification. And such a type of conduct is prohibited by law as a crime. Mistake as a doctrine can apply only to those elements where there is a mistake of fact and mistake of law divided into mistake of governing law and non-governing law. Mistake of fact, defendant thought, for example, that the umbrella which he possessed was his. Mistake of governing law, for example, when a defendant thought that he could take any umbrella, while mistake of non-governing law in which mistake of law that is not main law in question. Okay, let us start by mistake of fact. If the mistake of fact were reasonable, then accused shall not found guilty of general intent crime. But if mistake of fact were unreasonable, then he or she shall consider acted with culpable mind. Depending on the definition of offense, persons who acted exactly the same may be treated differently under mistake of fact. On another hand, accused shall not found guilty of a specific intent crime If the mistake of fact negates specific intent, portion of the crime, reasonableness shall not consider in such regard an issue here, but unreasonableness related to mistake code in such regard shall disbelieve honest mistake if really unreasonable, a result of mistake. If the mistake where take place, felon or defendant may be found guilty without morally blameworthy state of mind. Sometimes courts may convict the accused even if the mistake of fact negates intent, if the accused's conduct is immoral, even under facts as believed by her or him. Mistake of fact not considered an affirmative defense for strike liability crimes. Strike liability, okay? Because, as we said in last lecture, strike liability doesn't require not exemption but proving intent or guilty mind. Sometimes courts will convict even if a mistake of fact negates intent, if the field's conduct is immoral even under facts as believed by field. There are many types of mistake of facts. For example, mistake of ID of the victim. ID of the victim. Okay. This is valid mistake of fact in some certain states, like Deutschland or Strafrecht, okay, in Germany, and United States, it is no excuse where mens rea or guilty mind means only intent to kill a person, not specific one. Mistaken fact of the action is another type of mistake of fact. The third type, mistake of ID of prey. Okay, for example, who kills wrong person, but was intended to kill a person he was shooting at. This type of mistake of fact doesn't work anywhere in such regard. Mistake of fact as a defense. If the defendant proves that because of his or her mistake of fact, he didn't possess mens rea or guilty mind, then he will not be guilty of carrying charge or criminal liability shall negate in such regard. This is an affirmative defense, and that it accumulates the burden of production, which consider a part of burden of proof. We said that burden of proof consists of two folds: burden of production and burden of persuasion. That were about mistake of fact. What about mistake of law? Mistake of law generally doesn't relieve an actor of liability for commission of criminal offenses. because one of constitutional principles, certainty of law, sometimes calls rules that, when not found guilty, if the mistake of law negates intent, almost always the accused's mistake or ignorance of law were related to other law than the offense of for which he is being charged. In such a regard, we had to distinguish between mistake of non-governing law and governing law. In the mistake of non-governing law, in such a case of mistake, the court may dismiss a charge on the grounds that prosecution had not proven that the defendant did so intentionally. While mistake of governing law, we mean by it that we had to distinguish between two different of situations. The first situation that in which defendant lacks the mental state required for commission of the crime, guilty mind, and thus had valid defense, and that in which defendant still had whatever mental state is required for commission of the crime, and only claims that he or she is unaware that such conduct was prescribed by criminal law, which isn't usually recognized as a defense. The defendant could not avoid prosecution by simply claiming that he were not brushed up on the law. Ignorance of law doesn't give immunity from penalty of the crime. In fact, there is no way for upholding affirmative defense upon ignorance of law, governing law, for ignorance of definition of the offense committed. But the defendant may be acquitted for ignorance of law or ignorance that conditions specified in the definition were present, but may not be acquitted merely because he didn't know that such conditions constituted a defining element of the prescribed offense. Ignorance or mistake as to the penal law or penal articles is not a defense. Ignorance or mistake as to matter of fact or law is considered a defense if it negatives or negates mental state required to establish a material element of the crime. But if the defendant would be guilty of another crime, had the situation been as he believed, then he may be convicted of the offense of he or she would be guilty had that situation been as he believes. Absence of laws in statute requiring a certain mental state doesn't warrant the assumption that legislator intended to impose strict liability. Some variations, some varieties of ignorance should not be a defense. Those which indicate that the defendant still indicates to do what constitutes a legal or moral wrong or moral moral wrong. Okay, a guilty mind should face for the imposition of penal sanctions. In considering the defense, we must distinguish between where the defendant's lack of mental state, guilty mind required for commission of the crime, and thus have valid defense, and on the other hand, that in which the defendant still had whatever mental state needed for the commission of the crime, only claims that he were unaware that such conduct was or were prescribed by law and not recognized as a defense to allow an ignorance of penal law defense would allow it to be a shield for the guilty because it is hard to refute and would require far-reaching inquiries. اتكلمنا في المحاضرات اللي فاتت عن الركن المعنوي ومتطلبات الركن المعنوي وصول الركن المعنوي، واتكلمنا وشرحنا، بدأنا كمان في شرحها بالتفصيل النهارده. ومن النقاط الهامة جدا اللي بتقابلنا في التشارج الميستيك اوف فاكت والميستيك اوف لو، واحنا قلنا يا اولاد الميستيك اوف فاكت لازم يكون يعني عشان تكون considerable لازم هنا تكون ايه؟ لازم يكون في طيب ده بالنسبة للنوينلي والميستيك اوف فاكت ميستيك اوف فاكت and ميستيك اوف لو. نيجي للكاتيجوري الثالث وهو recklessly. Well, and recklessly defendants knew that there I risk and decide to take a risk anyway. And recklessly consider a lower level of culpability and lower level of guilty mind. And reckless intent crime are not common as offense, criminalizing purposeful knowing conduct. The degree of risk awareness is the key by which we could distinguish between reckless and knowingly. Defendant acts recklessly if he or she consciously disregards substantial and unjustifiable risk that the bad result or harm shall occur. This is a different form of knowing intent, where defendant must be practically certain of the bad result. The reckless intent tests into project. First one, defendant must consciously disregard substantial risk of harm. The standard of is subject in such regard. Defendant must know of the substantial risk. The second one, defendant must take justifiable risk, meaning that no valid reason exists for the risk. The standard for The standard for this prong is objective. If a reasonable person would not take the risk, okay, then the defendant's action is in taking is reckless in such case. The risk must be of such nature and degree that its disregard involves a gross deviation from the standard of conduct that law-abiding person would observe in the actor's situation. Recklessness means consciously disregard a substantial or unjustifiable risk of which he were aware that the material element exists and will results from his conduct. Unlike negligence, requires actors to be subjective aware of justifiable risk. A reasonable law-abiding person would probably not take the action under such circumstances. Recklessness in Egyptian penal law, although reckless conduct is not expressly defined as such in penal code, it gives rise to criminal liability in various contexts. For example, under article number 244, personal injury resulting from an error or an harm that is caused by offenders' gross breach of duties carries a penalty of up to 2 years in jail and fine which must not exceed £300. The same provision lists two other types of wrongdoing that give rise to liability if personal injury results. The first one, usage, liquor, or narcotics. The second one, refraining from assisting the victim of the crime. Such behavior in such regard defined as criminally reckless. Okay, moreover, Court of Cassation has defined criminal causation to include possible consequences of actions taken with disregard of potential harm to others and has thus endorsed criminal liability for recklessness general. في recklessly احنا قلنا الكاتيجوري الاربع كاتيجوريز اوكي purposely, knowingly, recklessly, well negligent. recklessly الجاني ما بيتعمدش احداث النتيجه ولا هو عنده awareness in the bad result practically certain shall occur. اوكي ولكن هو عنده الاويرنس بس واقفه عند مرحله الريسك ان هناك خطوره، يبقى هنا درجه الاختلاف في درجه اليقين. هو متيقن ان دي براكتيكلي هتحصل لكن هو بيعمل انها ما بتحصلش زي ما قلنا. هو يعني عارف ان هو بقى محترف وان هو عنده مهارات، عنده سوفت سكيلز، وبالتالي هيمنع تحقق النتيجه، لكن هو عارف ان فعليا وخيان هتحدث، لكن هو واثق من نفسه لكن درجة اليقين عالية. أما في الريكلس لا، هنا في خطورة، هو في خطورة مفيش يقين. طب حد يقول لي طب ما هو يقين، انا ما بسالوش ليه بابوس ليه، اقول لك لان هو ما تجاهدش ارادته لاحداث النتيجه، يعني ما ارتكبش السلوك بغرض احداث النتيجه. ريكلس لا، درجه الادراك خطوره، على الرغم من ان هو كان مدرك ان هناك خطوره، قرر ان هو يعمل تيكينج بالريسك. اوكي. طيب واحنا قلنا زي ما شرحنا من شويه مثال ليها الماده 244 من قانون العقوبات اللي هو الضرب، جرائم الاصابه الخطا. النيجليجنس بالنسبه لان النيجليجنتلي النيجليجنس defendant should be aware that conduct carries substantial and unjustifiable risk across the deviation from standard of care that reasonable person would observe in actors situation. Defendant should have be aware and doesn't need to prove mental. Actors situation allows courts to inject more subjective into deciding what standard should be used. The difference between reckless and negligent is all built around awareness. Awareness. The difference between reckless and negligent intent is the defendant's lack of awareness. While the defendant committing negligent intent crime are also faced with substantial and justifiable risk, they are unaware of it, even though the reasonable person would be aware. Thus, the first flaw of reckless intent test is simply changed from subjective and objective standard. The person acts negligently when he should be aware of substantial risk and justifiable risk that the material element exists or will result from his or her conduct. Negligence in Egyptian penal law, like reckless, negligent conduct is not expressly defined in penal code, but can give rise to criminal liability. The code provision that criminalizes reckless personal injury also criminalizes personal injury that is caused by offenders negligent or reckless of the law, and deemed is punishable by lesser penalty of up to 1 year in jail, detention, and fine which not exceed £200. Many other crimes in penal code sound in negligence with liability triggered by negligent carelessness or in variety circumstances. احنا قلنا يا ولاد في النجلنت الامور او الجاني هنا ما عندوش اجراء، ما عندوش ادراك، ولكن هنا الريزونبل بيرسون كان يجب ان يكون مدركا. هذا فيما يتعلق بالشق الثالث من او الصوره الثالثه اللي هي طبعا الريكلس او النيجليجنت. الصورة الرابعة والأخيرة. واتكلمنا عن النيجليجنس في الايجيبشن بينال لو، ان لها تطبيقات كتيرة زيها زي الريكلس. طيب هنتكلم بعد كده على ال elements and the criminal intent. Occasionally different criminal intent support various elements of the offense. If the crime require more than criminal intent, for example, murder crimes require more than criminal intent, requires general intent and specific intent. Okay. Each criminal intent must be proven beyond reasonable doubt for each element. لما الجريمة بتتطلب أكتر من صورة أو أكتر من ركن يعني معنوي، يعني قصد عام وقصد خاص، النيابة العامة عليها أنها تثبت القصد العام والقصد الخاص. في هذه الحالة أثبتت القصد العام من غير القصد الخاص، هيبقى هنا مش مفيش جريمة، لا مفيش الجريمة البروسكرايبد أو الموصوفة في النص. أوكي. Under the common law, every offense had just one criminal intent. In some states, every offense had one criminal intent unless statute specifies otherwise. When the law defines an offense, prescribes the kind of culpability that is sufficient for the commission of an offense without distinguishing among the material elements thereof. Such provision shall apply to all the material elements of the offense unless a contrary purpose plainly appears. Okay. عندي كمان figures تانية للانتنت زي malice aforethought. Malice aforethought is a special common law intent distinct for only one crime, murder. The definition of malice aforethought is intent to kill. Society consider intent to kill most evil of all intents. So malice aforethought crimes such as first degree or second degree murder or murder in Egyptian penal law, article number 230, generally mandate the most severe penalty, including death penalty in jurisdictions that allow death penalty like Egyptian penal law. No loose plain English law, the dictionary defines malice aforethought as the state of mind necessary to prove first degree murder. malice aforethought اللي هي نية إزهاق الروح، وهي شكل من أشكال القصد الخاص. أوكي. في الماليce aforethought prosecution must prove that defendant intended to cause death. Any intentional killing that doesn't involve justification, excuse, or mitigation is killing with malice aforethought. When a crime is committed with malice aforethought, this means that the perpetrator held malice of the victim, but another way malice aforethought can be defined as the crime being planned in advance. في بعض الأحيان مصطلح الماليce aforethought بيعبر عنه بالبرميديتيشن سبق الإصرار. Okay. Originally, proof of malice aforethought was the requirement in certain jurisdictions in order to convict someone of first degree murder. What's malice then? The term of malice refers to person's intent to injure or to kill. To injure or to kill. كلمة مالس أو مصطلح مالس يعني نية الشخص في الإيذاء أو في القتل. عشان كده سبق الإصرار هنلاقيه مثلا في المادة 236 و 240 من قانون العقوبات. malice can either be expressed or implied. Malice is expressed when someone deliberately intended to take someone else's life. Malice is implied when a person is killed, yet no proof exists that the killer was provoked. Implied malice may also exist when a crime is committed by someone who is said to have depraved or malignant hearts. malignant هنا ده expression اللي يقصد بها سرطان، ولكن يقصد بها النية الخبيثة. Okay, in several types of cases, the element of malice must be proven in order to carrying charge. For example, malice is often an element in crimes involving arson. This is because arson is deliberate crime and that perpetrator intends to start fire. بعض أنواع القضايا يجب إثبات طبعا القصد الخاص أو المالس aforethought. وزي ما قلنا مثلا على سبيل المثال في جريمة الحريق العمد، طبعا دي لازم يكون النيابة العامة تثبت انه عنده نية اشعال النيران. اوكي. Intending to kill is another way of saying malice aforethought. When mens rea is a Latin term that refers to defendant intention to commit crime as opposite to actual crime itself. Mens rea or intent is concerned only with the defendant's mindset, not with his ultimate action. An intent to kill doesn't need to be specifically expressed by the killer. It could be inferred based on killer action. For example, malice aforethought can exist if someone shoots another person with a gun. Okay. However, just because someone shot another person, that doesn't mean that he necessarily had an intent to kill. Perhaps he was just trying to defend himself or to stop person he shot from harming someone, or private defense or self-defense, and he accidentally killed that person in the process. It is up to court to decide whether there is enough evidence to support theory that defendant had an intent to kill or not. Proving of intent to kill may lie in the type of bottles the killer used, or even the accessories that can attach to the gun, such as Steiner. Depraved heart murder. Depraved heart murder is a killing that occur or take place as a result of a killer showing an extreme disregard of human life. For example, if someone can be charged with the depraved heart murder if he, in fatal Frank, shot the ceiling of his apartment, killing someone on the floor above him. Specific intent crimes under the common law. There's a distinction between specific and general intent. The basic difference between specific and general intent and specific intent crimes there is a requirement that individuals or defendants who commit a crime to have a certain intent or purpose when the crime was committed was committed, whereas general intent crimes don't. Some jurisdictions have done away with this distinction. Specific intent is the intent with highest level of culpability, highest level of awareness for crime and other than murder. Unfortunately, criminal statutes rarely describe their intent elements, specific or general, and judge may be required to define the level of intent using the common law and or the dictionary to explain what ordinary meaning. Typically, specific intent means that defendant acts with the more sophisticated level of awareness, natural or probable consequences, inference, intendance, consequences of voluntariness of conduct. So, if someone were accused of a specific intent crime, prosecution must prove that when he commit criminal behavior, he had request intent or purpose intent. This intent will be listed in the statute that defines the crime. If the defendant doesn't act with this intent or purpose, then he shall not be charged of the crime. Crimes that require specific intent usually fall into one of three categories. The first one, either the defendant intends to cause certain bad result, defendant intends to do something more than commit criminal behavior. Three, defendant acts with knowledge that his or her conduct is illegal, which is called censure. Transferred intent. We talked about transferred intent. We said that occasionally defendant criminal intent is not directed to what is a criminal or is a victim. Depending on the jurisdiction, this may result in transfer of intent, defendant intent from intended victim to eventual victim for a purpose of fairness. Although this is a legal faction, it can be necessary to reach just a result. Transferred intent is only relevant in crimes that require bad result or victim. Transferred intent is only relevant in crimes that require bad result. In a case where intent transferred defendant could receive more than criminal charge and more than one penalty, such as a charge of attempting and murder. Concurrence between act and intent is another element of criminal offenses. If the requirement that criminal act and criminal intent exists in the same time, this element called concurrence. Concurrence is rarely an issue of criminal prosecution because criminal intent usually generates the body response. However, in some rare instances, criminal act and intent are separated by the time in which case concurrence is lacking and a defendant could not be convicted of the crime. اتكلمنا في الجزء اللي فات عن بعض النقاط فيما يتعلق بالcategories of intent, purposely, knowingly, recklessly and negligently. اتكلمنا بعد كده على اشكال معينه من specific intent زي depraved hard murder و اتكلمنا على المالس افرثوت، واتكلمنا عن السبيسيفيك انتنت، ويمكن احنا ما ترجمناش لان احنا الكلام ده يمكن احنا اشرنا ليه في محاضرات سابقه فاتشرح قبل كده يعني. طيب هنتكلم بقى عن الموضوع اللي كل ده احنا كنا برضو بنتكلم على يعني البيزكس او الفوندمنتالز في الكريمنال انتنت. هنتكلم عن required intent element in environmental crimes. ده بقى ايه شغلنا احنا، او النقطه اللي هيبقى تبقى الانسكوب او هي الايتم الرئيسي في محاضرتنا النهارده. There are two types of forms of intent element in environmental crimes. Two types. Legislator may require for some environmental crime to commit intentionally. Okay? But some of these offenses can be committed recklessly or negligently. المشرع في قانون البيئة تطلب أي كاتيجوري من الكاتيجوريز اللي احنا قلنا عليها. معظم جرائم قانون البيئة intentionally purposely، لكن في بعض الأحيان بيجرم السلوك إذا ارتكب recklessly أو negligently. It also raises question about the rules which regulate its criminal responsibility and the possibility of variation criminal responsibility in the case of committing violated conduct by the others. Okay, vicarious liability. Critical problem in such regard. Critical problem in such regard. Regarding to criminal intent in environmental crimes is that one of the most important constitutional principle of legality, no crime, no penalty without law. Also, in the case of absence of intent, the criminal charge could not be held. The required intent in the environmental crimes in the forms in its forms, purposely, knowingly, reckless, and negligently, raises some critical problems. These critical problems are the following. In one hand, some provisions which criminalized certain conducts in Egyptian environmental law didn't determine type of required criminal intent. احنا قلنا ان الكاتيجوريز اوف انتنت الاربعه theoretically واضحه، لكن practically وتطبيقها بقى في الانفايرمنتال. تطبيقها في الانفايرمنتال لو، environmental law او environmental crimes بيواجهوا مشاكل كتير. اول هذه المشاكل ان النص نفسه ما بيحددش بشكل واضح هل هي مطلوبه intentionally ولا reckless ولا negligent. On another hand, there are some challenges concerned with the proving or inference of such element. entity ان انا اثبت، يعني ان كان intentionally تبقى واضحه شويه، لكن الريكلس والنيجليجنت اوكي النص ما بيبقاش واضح الدلاله. دي حاجه. الحاجه الثانيه، المشكله الاكبر اللي بتقابلنا البروفينج او اثبات النيه. اوكي because acts of pollution may be committed in many forms away of the perpetrator. في بعض الاحيان بتقابلنا مشكله المسؤوليه عن فعل الغير، اللي هي الستراك لايبيليتي والفاكيروس لايبيليتي واللي احنا اتكلمنا عنه. بعض الجرائم بيكون فيها التلوث من السبوردينيتس، من التابعين، التلوث البيئي من التابعين، الجريمه من التابعين، ويسأل عنها مدير المنشأة أو صاحب المنشأة. and it, and it may be difficult to ascertain whether or not perpetrator intended to violate environment, and the indictment authority may be unable to prove such intention. In addition, the indictment authority may not be able to rely on the assumption that the accused already has knowingly category of intent and directed his intent as well to commit a prohibited conduct that cause certain bad result that cause pollution, because it already contracts with constitutional principle. Particular principle of legality, which requires existence and proving either the act or criminal entity. وزي ما قلنا عندي بعض المشاكل اللي بتقابلني وانا بحقق في جرائم البيئه، وانا بحكم لو قاضي في جرائم البيئه، هل اول هذه المشاكل اللي احنا بنتكلم عنها وهنتكلم عنها بقى تفصيلا بقى في المحاضره دي وفي المحاضرات الجايه ان شاء الله. اول حاجه القصد الجنائي والكاتيجوري في القصد الجنائي اللي ممكن يكون هنا يحمل تشارج. هل الريكلس؟ هل النجلنت؟ دي نقطة. النقطة الثانية ازاي يثبت؟ تطلب القصد الجنائي اوكي امر واضح، لكن اثبات القصد الجنائي مشكلة. دي حاجة الثانية المسؤولية عن فعل الغير، وخصوصا المسؤولية عن فعل الغير بتتعارض مع مبدأ من مبادئ الدستور principle of legality، وبتتعارض كمان مع presumption of innocence قرينة البراءة. اوكي طيب elements of criminal intent in environmental offenses. طيب كنا بنتكلم عن elements of criminal intent in environmental crimes. Criminal intent exists if the offender in the case in which the offender were aware of his or her prohibited conduct and the certain required conditions and the required attendant circumstance, and it is uh, uh, the crime's elements and its crime and elements. And that his will is directed for committing prohibited conduct and causing such bad result if it required in material crimes. Knowledge that must be required. And the criminal intent must include within its scope the elements of the crime and for what departs from such elements. It must not be included in such regard regarding to knowledge of the law in general. It is assumed. So the offender could not relay his or her defense on the ground that he were not aware of such criminalization, but he could relay his defense on the ground that he has a mistake of fact. If such a mistake actually affects facts on his or her knowledge, if there are reasonable cause for such a mistake. Knowledge of the subject matter of the right being protected. Offender knowledge must include within its scope the right protected by law. So he must know that his conduct, either commission or omission, shall cause environmental pollution, for example. For example, in transporting or handling dangerous substances, one of serious environmental crimes. Offender in such crime must know that what he or she is handling or possess or transporting is prohibited dangerous substance that cause prohibited harm to the environment, that cause pollution or could cause pollution. Also, in the case of killing wild animals or birds in one of places specified by law, offender must know also the nature of such animal, such bird, on which his act had been committed, and that it was a wild animal or bird, and it is prohibited to kill or hunted or rated or possessed, and that he will know that his conduct shall factually and legally cause a certain bad result if bad result required in material crimes. Okay, that is stipulated and criminalized by law. So the offender must also be aware that the place where he commits a prohibited conduct is a natural result or one of the places where hunting is prohibited in due to the presence of endangered animals, which were determined by the decision of Minister of Agriculture or component governor. Also, the offender must know that his conduct his conduct would increase the radiation level beyond sample limits. So if he or she will believe that based upon reasonable ground, that this rate is within the limits, of prescribed rate, then this mistake shall consider mistake of fact and shall negate criminal intent, but ounce of proof in such a case shall fall on the offender, him or herself. Also, in the case of usage, machines, engines, vehicles that produce exhaust, exhaust, which exceeds the prescribed limits, offender must know the nature of machines, engines, or vehicles which he already uses, and must know also that these machines produce exhaust that exceeds the prescribed limits. Knowledge must also include the career or position of the offender that required by law for charge. Such condition is required in certain cases stipulated by the legislator in certain articles of Egyptian environmental law. For example, the obligation of the manager of public facility to take sufficient measures to prevent smoking in closed area, public area, as well as the obligation of the owner of the facility to take the necessity precautions to prevent leakage or emission or air pollution. بنتكلم او اتكلمنا في النقطه دي يا اولاد على عناصر القصد الجنائي في جرائم البيئه. قلنا القصد الجنائي سواء عام او خاص لازم يكون متوافر، ولازم النيابه العامه تثبته. والقصد الجنائي بيتوافر اذا كان الجاني عالما بحقيقه الواقعه المجرمه وبعناصرها القانونيه. مش بس كده، تتجه ارادته الى ارتكاب السلوك وتحقيق النتيجه اذا كانت جرائم من جرائم النتيجه وليس جرائم السلوك. هو عندنا في قانون البيئه في جرائم سلوك وجرائم نتيجه. يتحدد نطاق العلم الواجب توفره في القصد بانه يشمل اركان الجريمه. اما ما يخرج عن هذه الاركان والعناصر اللي بيحددها النص فلا يشترط ان يعلم به الجاني. العلم بالقانون مفترض، ولكن العلم بالقانون زي ما قلنا القوانين العقابية مفترض، فلا يقبل من الجاني الدفع به بأنه كان يجهل وجود مثل هذا التجريم، غير أنه يقبل الدفع بالغلط في الوقائع إذا أثر هذا الغلط على عنصر العلم الواجب لتوافر القصد الجنائي. من أهم عناصر القصد الجنائي العلم بموضوع الحق محل الحماية زي ما كنا بنشرح من شوية. فيجب أن ينصب بعلم الجاني على الإحاطة بالحق الذي يحميه القانون. فيجب أن يعلم أنه من شأن فعله سواء إيجابي أو سلبي كوميجن أو أوميجن أن يؤدي إلى تلويث البيئة. على سبيل المثال في جريمة نقل أو تداول المواد الخطرة يجب أن يعلم الجاني، ودي من جرائم البيئة، أن ما يقوم بتداوله هو مادة من المواد الخطرة التي يحظر تداولها أو يحظر تداولها بدون ترخيص. فهنا يجب أن ينصب العلم الجاني إلى أن هذه المادة من المواد المحظور تداولها بدون ترخيص أو المحظور تداولها على حسب الأحوال. وكمان أن ينصب علمه أن ما يقوم بتداوله أو نقله مادة من المواد الخطرة التي تحدث ضررا بالبيئة حتى لو ما أحدثتش ضرر بالفعل. أما إذا اعتقد الجاني أن ما يقوم بتداوله مادة لا تتوفر فيها هذه الصفة فده يعتبر هنا إيه؟ خطأ في الوقائع، خريطة ان يكون في ايه رزم ريزونز ينتفي به القصد الجنائي. كذلك في جريمة قتل حيوان او طائر بري في الاماكن التي حددها القانون اللي هي المحميات، يجب على الجاني ان يعلم ماهية الحيوان اللي بيقتله او الطائر، اوكي، وانه حيوان بري، وانه حيوان لا يجوز قتله او تداوله او حيازته. كمان ينصب العلم ان من شأن فعله ده ان يؤدي لاحداث النتيجة. كما يجب أن يحيط الجاني أو يشمل علم الجاني إن المكان اللي بيصطاد فيه ده محمية طبيعية، أو من الأماكن المحظور الصيد فيها لوجود حيوانات مهددة بالانقراض، واللي بيصدر طبعا بتحديدها قرار من وزير الصحة. كمان يجب أن ينصب علم الجاني على عناصر السلوك الإجرامي، أي إن من شأن فعله أن يؤدي إلى تحقيق النتيجة اللي جرمها المشابه. على سبيل المثال آه، في جريمة النفايات المشعة، أوكي، يجب أن ينصب علم جاني إن فعله ده من شأنه أن يزيد نسبة الإشعاع عن الحدود المسموح بها. حدود الإيه؟ المسموح بها. فسأعتقد إن فعله ده، إن النفاية المشعة أو معالجة النفاية المشعة أو المادة المشعة تصدر إشعاعات في الضوء في الحدود المسموح بها، هنا يعتبر خطأ في الوقائع، وده طبعا يعمل نيجيتس لللايبيليتي. كذلك الحال في جريمة استخدام آلات أو محركات أو مركبات أو مركبات ينتج عنها عادم يجاوز الحدود المقررة، المادة 36 من قانون البيئة. أوكي؟ يجب أن يعلم الجاني في هذه الحالة بطبيعة ما يستخدمه من وسائل، من آلات، من معدات، من محركات، وأن من شأنها أن ينتج عادم يتجاوز الحدود المقررة. يلحق بوجوب توافر العلم أن كمان، بالإضافة لتوافر العلم بالعناصر اللي احنا قلنا عليها، كمان توافر العلم بصفة الجاني هي إحدى العناصر المهمة في بعض الجرائم، حقق ذلك في بعض الصور اللي نص بها المشرع في في قانون البيئة على ضرورة تطلب صفة معينة في الفاعل. على سبيل المثال التزام المدير المسؤول عن المنشأة باتخاذ الإجراءات الكفيلة بمنع التدخين في الأماكن العامة المغلقة. لازم يكون عارف إن هو مدير وإن ده من التزاماته. كذلك التزام صاحب المنشأة باتخاذ الاحتياطات اللازمة لمنع تسرب أو انبعاث ملوثات الهواء. أوكي؟ هذا فيما يتعلق بعناصر العلم في جرائم البيئة. هنيجي على الإجنورانس أو mistakes and its consequences in environmental crimes. ودي إن شاء الله من الموضوعات المهمة جدا اللي هنتناولها بالتفصيل إن شاء الله في المحاضرة الجاية. مش عايزين نثقل عليكم أكتر من كده، عشان إحنا دلوقتي وصلنا الساعة 11 تقريبا، فإحنا مش عايزين نثقل عليكم أكتر من كده. هنكتفي بالقدر ده في محاضرة النهاردة. عندنا محاضرة تانية بكرة إن شاء الله. محاضرة بكرة إن شاء الله هتكون في نفس الميعاد.